We'll call the meeting to order. Today is June 6th, and we're shortly after 10 o'clock. I'm Judge Lauterbach, Vice Chairman, conducting the meeting in the absence of Judge Kraft, who is not able to be here today because of a trial he's involved in. So we'll call the meeting to order. The first issue we need to take up is probably the approval of the agenda. So, do you have any questions about that? Motion to approve that.
So moved.
Have a second. All in favor, say aye.
Aye.
Let's see, Miss Whaley, why don't you introduce yourself and then you can do the roll call because the last time we actually were here in person, you weren't here.
No, I am Kimberly Whaley. I am the Director of Licensing for the Division of Regulatory Boards. I work directly for Assistant Commissioner Giannini, and I am serving as the Director for the Private Probation Service Council. As many of you know, Director Hancock retired in September. Additionally, Susan Lockhart, who's been with the Commission and the Council for several years, has left us. She has gone on to better things at the Department of Health, and I would also like to take this opportunity to introduce your new Assistant General Counsel, Ellery Richardson.
Welcome. And before you do the roll call, I will introduce Stancil Ford, who's to my left over here. He is, this is his first live in-person meeting, and he replaced, let's see, Cindy Chisholm. So if you want to do the roll call.
Yes. Chris Kraft, Klein Lauterbach,
Here.
John Hudson,
Here.
Hugh Harvey,
Here.
Dina McCullough,
Here.
Stancil Ford,
Here.
Veronica Thornton.
Here.
You have a quorum, sir.
Let's see, looking at our agenda.
I have the notice of meeting.
Okay, we got on here determined necessity. I don't think we need that
Yes,
here today
we-
because that was when we were doing
We'll
the
remove
telephone
that.
thing. And so the agenda, I took that out of order. We already approved the agenda. So we'll next review the minutes from the last meeting, which was a telephone conference meeting.
And actually, Mr. Lauterbach, if I may read a notice of meeting into the record real quick.
Okay.
This meeting's date, time, and location have been noticed on the Tennessee Private Probation Service Council's website, included as part of this year's meeting calendar since August 16th, 2013. Additionally, the agenda for this month's meeting has been posted on the council's website since May 30th, 2014. This meeting has also been noticed on tn.gov's website.
Oh, I forgot to call that. I didn't see it on
That's
here.
okay.
And in meetings past, that's not something we would do, but now it's.
Yes, sir.
That's okay.
It's
That's okay.
part of the canned program
That's
now.
right. That's okay. It's nice to have. So then we'll move on to approval of the minutes from the last meeting, and they're in their folders, and we should have received them by email after the last meeting. So if you'll take a second to look over those.
They're under tab 1.
Questions about the minutes from the previous meeting? If not, is there a motion to approve those?
So move, Mr. Chairman.
Just second.
Second.
All in favor, say aye.
Aye.
The next report on our agenda is called the Sunshine Law Presentation. So,
Yes, legal has a presentation for you. I'm going to introduce Michael Driver. He is the chief counsel for regulatory boards.
significance to the name, Sunshine Law? Okay, never mind. Not just a pretty day, so.
Morning, everyone. I appreciate y'all being here today. I'm Michael Driver. I'm Chief Counsel with Regulatory Boards. I've been with the department since February 2008 in various capacities, and happy to be here. I'm here this morning to introduce Damon Romano, who's going to be doing a presentation. He was an intern with our department. He's a recent graduate of the Belmont School of Law. And will be sitting for the bar soon, and did a great job of putting together this presentation, and did so well that we were asked to go around and give it to all the various boards and commissions. I'm here if you have any questions afterwards, as is Ms. Richardson, your new counsel. So without further ado, I'll turn the mic over to Mr. Romano.
Before he starts, will you review us these, never mind, it says I'm speaking, so it's on.
Oh,
The
yes.
little light comes on when I'm speaking. Okay,
Yes.
good.
Make sure if you're making a motion or if you're speaking regarding something that your mic is red. And if not, I'll wave at you or I'll unfortunately interrupt you just to make sure we catch everything on the recording for the record.
Go ahead.
Thank you, Judge, and thank you all for being here this morning. And I know that you all have come in from every which way, and that there was a little bit of a traffic blockage, and Bonnaroo's not till next week. So I appreciate you for carving out some time on your agenda for me this morning. As Mr. Driver said, this is a presentation that that has been shopped around to fairly well all of the regulatory boards and commissions within the department at this point, for a number of reasons. First, there are some new members that haven't had any formal introduction to this material in probably half a dozen years. And then for very long-serving members, we've found that some misconceptions or cobwebs have kind of crept up over the years. And the idea of me going around to give this presentation is to clear all of those away, make sure we're all on the same page going forward, and that we're up on any changes in the law. I understand that we have some judges on the council this morning, and so the tenor will slightly, but it's a presentation that by and large is designed for general consumption. When we talk about the Sunshine Law, we are talking really about two acts in Tennessee. We're talking about the Open Records Act, and we're talking about the Public Meetings Act. I'm going to spend very little time this morning on the Open Records Act, folks, because that, by and large, on a day-to-day basis, is something that's handled by Executive Director Whaley and her staff, dealing with Freedom of Information Act requests, things like that. Excuse me. So briefly, what's included then in open records as far as your council is concerned? We'll see the law here says all documents, papers, letters, maps, books, photographs, microfilms, electronic data processing, files, and output, films, sound recordings, or any other material, regardless of physical form or characteristics. So what's included, what is liable to be included? It's just about everything, which means that just about everything you all produce in terms of minutes, documentation, record, is subject to an inquiry. Doesn't mean that it's necessarily going to be released to the public, but it's subject to being requested. And again, for those of you that might not know, Tennessee has an entire Office of Open Records Counsel that deals with legal questions pertaining to these records requests and what can be released to the public and what can't for sensitivity reasons, things like that. But again, on a day-to-day basis, it's going to be Executive Director Whaley and her staff that deals with it. So then the other big component, and what we're going to spend the bulk of our time on this morning, is the Public Meetings Act. We'll talk about what your requirements are under the Act, what is a meeting for the purposes of the Act, and then what's not. We find that there's some confusion there, and so we'll try and put some fences and boundaries around it. The four big components, notice agenda is not necessary, but it's the conventional form that we've chosen. Public presence and minutes. Ladies and gentlemen, we'll find that once we deal with notice and once we deal with what a meeting is and what it's not, we will have covered about 95% of what you all are responsible for in your capacity as members of this council. And then finally, what happens if you violate the Act? What happens if you go behind closed doors and conduct some significant portion of this council's business off the record? Briefly then, we'll say that the answer is nullity. The courts are going to go back and rewind and pretend as though it never happened and then go forward again from there. And it doesn't sound like much, but we'll see as we go forward. It can have some fairly astounding consequences. All right, so let's dig into it a little bit. This morning as we go forward, I will cite some law at you, and I don't want to bury you in legalese, folks, but there are a couple of really important court cases that I will break down and tell the story of as we go on. Here we are. The General Assembly hereby declares it to be the policy of the state that the formation of public policy and decisions is public business and shall not be conducted in secret. That's our general rule. Formation of public policy then, as applied to you, and the courts have settled all this out, is going to be your rules and regulations anytime you undertake to amend, delete, add new rules and regulations. That's public policy. Everything else you do, discipline against a license, revocation, issuance of a new license, all of that falls under the general heading of decisions. All has to be on the record. This is simply the free speech clause of the Tennessee State Constitution, excuse me, telling you that, look, you do not give up your right to free speech as a citizen of the state when you volunteer to serve on this council. However, you have volunteered to serve on the council, okay? And so you are agreeing that anything you say and most of the things you do are liable to be put on the record. In other words, the legislature is not telling you what you can and cannot say. They're saying that when you act in your capacity as a member of this council, whatever you choose to say needs to be on the record. The act is remedial in nature, meaning we can't fix a problem until after it arises. It should therefore be construed broadly to promote openness and accountability in government. That accountability is sort of our key word there. What the state legislature is doing, and sort of the heart of this whole thing, is that in your capacity as members of this board, y'all are not elected. You've been appointed. And so if the people elect a governor and they don't like that person's decisions, they can vote him out of office. They can find somebody else. You all have been appointed. If the public doesn't like the way that you're going about your business, they can't vote you out. So these sunshine laws are here to provide some accountability, to give the public a net that they can put their hands around and shake vigorously if they have to, so that the public knows what's going on. Here we will see this very broad, very expansive, all-inclusive language. All meetings of any governing body are declared to be public meetings, open to the public at all times, except as provided by the Constitution of Tennessee. That exception at the bottom is our executive sessions exception. We'll talk about that in more detail in a few minutes. The previous slide told you that all of your policies and all of your decisions were matters of public record. This part of the code is telling you that all of your meetings are matters of public record as well. What is a governing body? Governing body is the members of any public body which has two or more members with the authority to make decisions for or recommendations to a public body or administration. Hang on. If the law applies to governing bodies, but a governing body is just a kind of public body, aren't we just moving the problem back one step? They have sussed this out at the Court of Appeals and at the Supreme Court to mean that we're trying to pick up our committees and subcommittees. Meeting, again, means the convening of a governing body of any public body for which a quorum is required. In other words, the question came up, and it had been a problem in years past, where you would have a regulatory board or commission say, okay, we understand that we're required to have our plenary meetings, the meetings of the whole board or commission, on the record, but we believe that we can get away with having our committee or subcommittee meetings behind closed doors. No, and there was a big fuss over that about 15 years ago. Excuse me. So all of that is going to be picked up. What's not a meeting? Some of our board members and commissioners then have gone to the opposite extreme, and they've become ultra scrupulous about the whole thing. And then they're paranoid and they feel paralyzed about it. A meeting, for example, does not include any on-site inspection. For example, we have the Motor Vehicle Commission that regulates the licenses of car dealerships and car salesmen. They will routinely and regularly send out investigators or inspectors to these car lots to make sure that they're complying with the various laws. That would not be considered a meeting of the Motor Vehicle Commission for obvious reasons. We can see how that would get bogged down very quickly. A meeting does not include, and here we get kind of into the meat of it, what's sort of been a problem in the past. Meeting does not include a chance meeting of 2 or more members. However, no such chance meetings can be used to decide or deliberate public business. This is the spirit of the law clause. Excuse me. So if Mr. Ford and Judge Harvey, y'all run into each other at the Piggly Wiggly over the weekend and happen to talk about the weather, your children or grandchildren, whatever it happens to be, that's fine. That's not a meeting of the council. But then you shouldn't undertake to discuss the business of the council. Excuse me. We have here what I like to think of as our 3 Ds: decide, deliberate. Later we'll see debate. Decide, deliberate, and debate. Those are the 3 things you cannot do unless you are on the record, under the gavel. There's a 4th D, discuss, and we'll see an Attorney General's opinion about that right here. 2 or more members, this comes out of the Attorney General's office, his opinion. 2 or more members of the public body may share a meal together in which public business is conducted, but that discussion should not constitute deliberations. And what I have said, and I'm aware of my audience this morning, but what I have said in the past is, folks, if you can accurately determine several months ahead of time what a judge is going to say in the future as to whether or not your conversation over lunch was discussions or deliberation for the purposes of this act, you're smarter than I am. This gets to sort of our razor's edge of the appearance of propriety. And I would suggest to you it's best to avoid it altogether. Discussion of council business outside of it. What else is not a meeting? This is from that same Attorney General's opinion. Any kind of lunch breaks, restroom breaks, smoke breaks, recesses between morning and afternoon sessions, or if you have, God forbid, a multi-day meeting, that overnight adjournment would not be considered a part of that meeting. But again, those are times when discussion of your business should be avoided. Regular meetings and special meetings also count as meetings. And by the way, under special meetings, there are also emergency meetings. Occasionally, you will have a board or commission that has a licensee that has become a very bad actor very quickly. And if that board or commission only meets quarterly, they might say, we can't wait until September to take action here. And so they'll establish emergency meeting. Even the emergency meetings have to be, you'll find they'll be scheduled 3 weeks or so out because courts have said they fall under the Sunshine Law, and therefore we have to give adequate public notice sufficiently ahead of time. Again, that executive session exception, so let's talk about that. 3 things have to obtain. You meet with your board attorney, Ms. Richardson, and as a counsel, you're either being sued or under threat of suit, and you are there to ask questions of legal significance related to that suit or potential suit. So I get done bothering at you about this here in about 2 more hours, and then you go out into the hallway. And you've made some decision, and some licensee comes up to you and says, I really don't care for how y'all decided that. I'm going to sue you. That's enough. Your threshold is met. You now can go into your executive session behind closed doors, speak with Ms. Richardson, and inquire of her and seek her sound counsel related to that suit. And by the way, the courts have said, look, it can be borderline hypothetical too. And in other words, you all have a fairly broad latitude to go into this executive session to seek legal opinion, again, for that attorney-client. You're the client collectively as a board. Council may not deliberate about any matter, any specific matter, either before it or potentially before it during an executive session.
That relates to the lawsuit.
Then you can seek, it's like this. If you go into an executive session, Judge, and you say, we think we're about to be sued, or we have been sued, Ms. Richardson, give us your counsel as to, what are the ramifications of this? And you ask her questions and she answers your questions, fine. If at any point, say for example, Judge Hudson looks over at you and says, well, based on what we've heard from her, I think we ought to do X. That's where we stop. That kind of crosstalk among the members is going to constitute our debate or our deliberation, and that's where we have to back off.
What if that's dealing with the issue of resolving the lawsuit? And you're wanting the attorney is going to resolve the lawsuit.
My understanding, Judge, is that you have a fairly broad latitude to stay in that executive session. My encouragement to you would be to say something like this. If you, and by the way, let me interrupt myself for a second. Part of your board attorney's job is that if she thinks you're crossing the line into debate or deliberation in this executive session, she's supposed to put the brakes on it as well, as part of keeping you all out of trouble. Okay, having said that though, it's not unreasonable that you might come back out of an executive session, get back into the committee room, get back under the gavel and on the record and say, here's in broad terms sort of what we discussed in an executive session with our attorney. You can maintain your own attorney-client privilege and say, just make brief mention of the fact for the of business X was discussed specifically within the context of answering the legal question. And cover yourself there. That question, by the way, is addressed in an opinion of the Open Records Counsel, Alicia Hodge. And if you haven't visited the Open Records Council's website, I highly recommend it. The opinions coming out of her office are very helpful, very informative, and top-notch. Does that answer? How far does it go? Here's another opinion of the AG. What we have here is the Maury County Civil Service Commission. They were doing first-level interviews of people to create a vetted list, and from this vetted list, the list would be sent over to the Sheriff's Department, and from that list, new deputies and new Sheriff's Office, Sheriff's Department staff would be hired. And so what they did was they would conduct these interviews, and then they would go behind closed doors and discuss, okay, well, which candidate do you like, which candidate do you how to be hired. State Attorney General says those meetings after the fact of the interview are very likely to be covered under the Open Records Act. Why? Because that piece of business, picking the people who are eventually going to be hired by the Sheriff's Department, is of critical importance, as you might imagine, to the public well-being. And so the public interviews even, the discussion about job interviews is going to be something that is probably subject to the Open Records Council, or excuse me, the Public Meetings Act. Let's talk about electronic communications briefly. If one of you were to email the chair and say, I've read a news article about our business, our council business, or this profession, fine. If you say, I've read this news article and I think it's an important piece of business and I'd like you, Mr. Chairman, to include it on the next agenda, that's fine. But if you then say, I read a damning article that was that had some very nasty things to say about one of our licensee companies, and I think we need to take action. Stop. Now we have gotten into the area of debate. You are offering your commentary on how you might decide the issue when it comes up for a vote. That's exactly the kind of thing that needs to be on the record. back and forth between you and your board counsel, though, is a lot more liberal, a lot more open and free. If you say, I have a question about the consequences, the legal consequences of something I've done in my capacity as a member of this council, for example, you might go to talk to a trade group or go to talk to a high school about the industry that you're regulating. And you did it without the approval or the opprobrium of the full council. The council might be upset with you about that. If you're presuming to speak on the council's behalf without that authority having been granted, that might be a problem. And so you might go to Ms. Richardson and say, what do I do? How do I fix this? How do I avoid doing it again? That's perfectly legitimate. If you get picked up for your 19th DUI in 15 days, she's probably not going to be able to help you with that. And that's where you would need to break off and go seek your own attorney. Remember, she is your attorney for the council and in your individual capacity as a member of the council, but she's not your personal attorney. I want to back up real quick to this Maury County thing and say, how far does it go? There was a case in the fine print at the bottom of the slide, a few slides back. Town of Kingston Springs, Aiken v. the Town of Kingston Springs, come out of the western section of the Court of Appeals. I want to say it's 96, but it's in the slide, and I'll forward that to you. But what you had there was the city of Kingston Springs, Tennessee, undertook to annex some of the county land around it, and when they got together as a full town council to decide the up or down vote on whether or not to do the annexation, they did conduct that vote on the record under the gavel, properly noticed, everything was fine. However, prior to that, they had made all of their decisions about where to draw the annexation lines behind closed doors. And so people got annexed and didn't know that they were about to be annexed, and as you might imagine, they got upset and they sued. The court eventually came down and said, because they took the up or down vote on the record, and because the plats, if you will, of what was going to be annexed were part of the record of the publicly noticed up or down vote, then it cured the violation. But the court noted there absolutely was a violation of the Sunshine Law preceding when they made these decisions about who to annex and who not to. And it's at that point, usually in my presentation, when I suggest to the non-lawyer board members or commissioners that, folks, if you get sued, you've already lost. Because the giant black hole of staff time, budget, money, it just goes on forever. And a lot of these cases don't get solved until they reach all the way up to the state court of appeals, or in some cases the state Supreme Court. What you realize then is that by the time you've gotten to that point, you've done that dance 3 or 4 times, and then you've got to come to Nashville, and you've got to give testimony, and so on and so forth. And it's, to call it a pain in the neck is the understatement of the century. Your honors are well aware of that. All right. Let's talk briefly then about electronic attendance. Your prior meeting, I heard you say, was conducted telephonically. That's fine. If one of you can't be here in person but wants to participate telephonically, that's fine. Here's the caveat, though. You're going to have to drop back to having all roll call votes. This all in favor say aye, all opposed say no. You can't do that if somebody's coming in over the telephone, because again, the public has a right to know who's voting how, okay? And so we're going to have to do a roll call vote. Mr. Ford, how do you vote? Ms. McCullough, how do you vote? And so on for all of those. And then you can go forward as normal. If the number of people, just as we have today, if the number of council members that are physically present in the room does reach a quorum, then you just go on as normal. What happens if you don't have enough people here to make a quorum, and the only way you get to a quorum is by including the people that are coming in telephonically over the PA system. You can still conduct a meeting on the record, a statement. Doesn't have to be very formal. You're just speaking something on says words to the effect of, we understand that the rules require us to have a quorum in person. However, we also understand that we have a mandate to do this work from the state, and the only way that we can get through our agenda in a timely manner and to end a little bit on the attendance and include people telephonically. And so now, having made that statement of necessity for the record, formal. Again, we'll see the act is to be construed most favorably to the public, is all-encompassing, applies to every meeting of a government body except where the statute on its face excludes the application. That exclusion does not apply to you. That's the short answer. Excuse me. That has to do with those boards or commissions that have the authority to definitively commit the public fisc or the state treasury to certain actions. And we'll say, even if those people violated the Sunshine Law, we're not going to unwind it after the fact because the contracts have already been made, the buildings are already under construction. It would cause more harm to fix it than to just leave it alone. But there are other penalties that would then accrue to the violators. Excuse me. That's not what we're dealing with here, so that's okay. This is the other case that I wanted to mention to you folks, the Shelby County Board of Commissioners. Sort of a sad story. You had one of the long-serving members of the Shelby County Commission passed away in office, and he represented a strongly minority district and was well beloved by his constituents. And so, out of the however many 10 or 20 some odd members of them got together and decided that it was a moral imperative that whoever replaced them, because it was the commission's responsibility to appoint somebody to replace the gentleman who passed away and fill out the remainder of his term until you could have another election. And so they felt that it was a moral imperative to get somebody in from the local community, from that same neighborhood, to represent that strongly minority area. And so they had a series of phone calls between and among up to a short list, and then they eventually came up to one name. And one of the members called this gentleman and said, if we appointed you, would you serve? And he said, yes. Fast forward to the next full meeting of the Shelby County Commission. And they were all there, and the chairman starts the meeting by saying, we're very sorry for the loss of this commissioner. It's a shame. We offer our condolences to his family. We need to fill out the rest of his term. We're required to appoint somebody. Are there any nominations? One name was mentioned. Is there any discussion? No discussion. All in favor say aye. Unanimously in favor. The gentleman comes up from the gallery. They swear him in. He takes his seat and he begins to serve. As you might imagine, somebody in the gallery said, well, that doesn't sound right. There was only one nominee. There was no discussion as to this gentleman's qualifications to serve as a county commissioner. No, nothing. And so they sued. And sure enough, and it, again, runs all the way up to the Tennessee Court of Appeals, excuse me, where they said this is a textbook violation of the Sunshine Act, of the Public Records Act, that these three other commissioners would undertake to do all of this in secret behind closed doors without letting the public know about it. You've cut out the entire electoral process, or in the case of an appointment to fill a vacancy, you've cut out any kind of accountability at all. And so again, we talk about the penalty for violating the Sunshine Law is nullity. The Court of Appeals went back in time to the moment that man was appointed and said it was as though he was never appointed. It was as though it never happened. And you say, okay, well, that's a shame and it's a sad story. The thing is, folks, it doesn't end there. That flows downhill. Now, every subcommittee of which he was the chairman, every committee that he cast the deciding vote on, all of that is now called into question. And a lot of it was wiped away. And so what you have is, folks, Shelby County is not a small place. And the county comes to the business of the county comes to a grinding halt, and a good deal of the business they had conducted over the past several months while all of this litigation was churning on was undone. It was chaos. And all of this is in the record of the case. Excuse me. So, but it's an object lesson that even with the best of intentions, even trying to protect the constituency of that neighborhood or of that district, even trying to pay respect to that long-serving member, they did a whole lot more harm than good. And so a scrupulous adherence to these sunshine laws is something that we ought to be seeking. The public then has a right to observe your meetings, but not the right to participate. So somebody in the gallery in that Shelby County case couldn't stand up and say, hang on, that's not right. You may allow the public to speak at your meetings. You may also put reasonable limits on it. Say, look, we are only going to allow 30 minutes, I don't know, for total public comment, and no one person can speak for more than 60 seconds. That's fine. As long as you treat everybody the same, that's fine. You're not required to let anybody speak at all. The idea is the legislature has charged you with doing the work of a particular piece of government, and you have an agenda to get through. All right, I said before that once we dealt with what a meeting was and what it wasn't, and what you were required to do and what you were prevented from doing or prohibited from doing under a meeting, and then once we figured out notice, we'd have about 95% of what you all need to worry about. And so let's talk about notice. There's a three-pronged test: contents, timing, and location. The contents of the notice have to reasonably describe the purpose of the meeting. It's reasonably described. There are some board members and commissioners who feel as though those agendas that get published are like Charlton Heston standing on top of the mountain with the commandments, and it's graven in stone, and you can never alter. Is that if there is a matter of particular interest to a member of the public, they can look online, see that agenda, see that the issue that they care about is going to be discussed sometime at this meeting today, and have a reasonable time to show up at this meeting that the thing that they care about is going to be talked about by you all. But it's not in lockstep, it's not graven in stone. And we can see that because the bottom of every agenda has a line item that says new business. Well, nobody knows what that is before you get to it. So there you go. You're not locked down to it, but it does have to reasonably describe. You can't ignore your agenda either. If you have the most informative agenda in the world and you publish it 20 minutes before the meeting, that doesn't do anybody much good. And so we're going to say that the notice has to be posted at a time enough ahead of time of the meeting to give citizens an opportunity to become aware of it and to attend. Excuse me. The rule of thumb, by the way, in the courts, in the decisions that have come down in Tennessee, is about a week to 10 days. Varying decisions have said 7 days, 10 days. You'll find if you were to look at your council's website, I think all the meetings for the next year are already up there. So we're ahead of the curve on that. If you give the best notice in the world a year ahead of time, but the only place you post it up is in the basement next to the boiler room, what good does that do anybody? So we're going to say that the notice has to be posted in a prominent location where anybody can get to it. The usual methods used to be newspaper, and you may recall that phrase, newspaper of general circulation or newspaper of wide public. That was to prevent largely municipal governments, counties, from holding property auctions or seizure auctions and then only posting the notice in the local grocery store flyer. All right, so you've got to have a newspaper of general publication. We don't use newspapers anymore at the state level, although they do still a lot at the local level, because we have the item of widest possible circulation. We have the internet, and you'll find that your agenda for today is posted on your website, private Probation Services Council website, and also on the larger Department of Commerce and Insurance website. And now I'm to understand that there is an email blast that a member of the public could sign up for, say what they cared about, or something, and that when the time came, the agenda or the notice of that meeting would be shot out to them in a text or an email. Pretty cool. And then bill posting, just stapling up flyers everywhere. We don't really do that anymore. Although every time you come in for a meeting, you'll see that there's a little flyer posted in the lobby saying, your meeting is this way, so that people don't say, well, it's a big building, I got lost, and therefore I didn't have notice. All right. Again, we have a Tennessee Attorney General's opinion backing all of that up, saying that our usual practice is to publish notice on the department's website and the commission's website. That notice test, whether or not you gave enough notice of the right kind, you have to do all three. You can't say, well, we gave the notice of the meeting 2 years in advance. Doesn't that cover us if the contents of the notice were a little thin? No, you've got to do all of it: the contents, the location, and the timing. We talked about the idea that the legal effect is nullity, and we talked about that unfortunate incident in Shelby County. There is a practical impact. There is a case hot off the presses, Little v. Chattanooga, filed on Valentine's Day of this year. This is not a public meetings decision, folks. This is an Open Records Act decision, but the two are very frequently intertwined. It's controlling for its scope. It's a fairly limited scope, but it's a limited scope that could very easily apply here, depending. Miss Little sued the city of Chattanooga over an open records request that they declined to grant. One thing leads to another, and 5 suits later, because it goes from trial court to appeals court, back down to trial court, back up to appeals court, and back down to the trial court again before it's all resolved. She asked for $70,000 in legal fees and costs, sort of in contravention of the standard American rule that everybody pays their rate. The trial court denied it and said, no, you pay your own attorney. The court said, look, but for the city of Chattanooga's bad act, she wouldn't have had to sue you. She wouldn't have had to incur these costs, and therefore, yes, the city needs to pay her costs, and sent it back down to the lower court to do that. And then the lower court said, well, $70,000 is excessive. We're cutting it off at some significant amount lower than that. I think it was about. And they said, no, not half, not a portion, not a deposit, all of it. Because all of it, it's not excessive legal costs. It's not that the lawyer was trying to bilk the city. At least there was no evidence of that. It was that, again, she wouldn't have had to incur these costs but for the bad act of the city. Excuse me. So there is a controlling opinion in Tennessee now that seems to suggest that under certain circumstances, legal costs for a violation of these could be assessed against the Border Commission.
Limited just to the Public Meeting Act or Open Records Act?
The
language of that case?
That case, Judge, was an Open Records Act case.
Okay.
Although we're waiting on Open Records Council to issue a formal opinion on it, we believe that it could apply to open meetings as well, because the facts.
What about past that? Is it setting up a sort of a standard for bad acts are going to entitle the winning party to recover attorney fees?
No, Your Honor, it's not that general.
And I think the opinion on its own is pretty limited to records. I don't.
What was the basis for it, though? Does the Records Act provide for that?
It does.
It provides for
Yes,
attorney
sir.
fees? Well, then
Yes,
then you
Your
don't have
Honor.
any problem then about, you're just saying that the winning party's entitled to attorney fees, so you don't have to address the bad acts part, do you? If it's in the statute?
That's correct. That's my opinion.
It's a big door to open if it starts to say you can recover. That's, we don't generally have that.
Yeah, that'd
Anyway.
be a huge door to open. But I don't think we're near there personally.
So that's where we are with that. So to sort of sum up then and let you all get back to the rest of your agenda, the Public Meetings Act is designed to make sure that all regulatory boards and commissions and all of their business is conducted in a way that's accessible to the public. It certainly applies to you both as a plenary council and in your individual capacity as council members. All of your meetings are covered, including your regular meetings, your special meetings if necessary. Any emergency meetings have to be on the record under the gavel. The only exception, again, is that executive session where you can go behind closed doors with your board counsel, Ms. Richardson, and seek her opinion suit or potential suit you might be facing. Excuse me. And then for every meeting, you have to give adequate notice in content, location, and time. If you violate the law, even unintentionally, the violative acts are void, and we've seen how that can kind of flow downhill. The little decision is somewhat limited, and we say that the best way to protect yourself is to be scrupulous. We want to avoid that appearance of impropriety. I mentioned earlier the idea that if you're emailing one another, there is some content that is okay. If you happen to email one of your fellow council members and say, I saw your granddaughter in the school play the other week, and gosh, wasn't she cute? Or I heard you all got caught up in that bad ice storm last week. Is there anything we can do to help you? The content of that is fine. But before we get to discovering the content, what's the public going to see first? The first thing they're going to see is that the members have been communicating with each other outside of the context of a meeting, and it raises a red flag. It gives the appearance of impropriety, and it's something that we feel ought to be avoided unless necessary. Are there any questions? I or Ms. Richardson or Mr. Driver would be happy to answer them.
Driving down the highway, I pick up Mr. Ford over here because we're riding together, and I didn't get the agenda because my email didn't work out right or something, which in fact is true. And so he says, I've got the agenda, and it's on his cell phone. And he opens up, and I'm flying down the highway, and he starts reading it to me. And at what point do we stop talking?
He's reading the agenda to you.
He says the agenda is going to include, let's say something, some issue we might have, not a particular complaint, changing a regulation. And it says on here, we're going to review changing the regulation, this military thing, he just
Right.
says that. And I say, I don't know what that is. And he says he doesn't know what it is. So we don't have anything to discuss about it. What if it's one that it's been mentioned before at a meeting?
I would say once you get to the point you haven't expressed any sort of opinion regarding what you would like to do about the thing. So you can say, this item is on the agenda, that's fine. Once you say,
What about discussing, not whether we're for or against it, but what it is?
well, that's that line I think Damon mentioned between discussion and deliberation that the courts have drawn, and you're getting very close at that point. Once you're even discussing, because it's hard to separate, at least for me, between, even discussing what the thing is and making some value judgment as to whether or not that's a good idea, bad idea. So I would certainly caution you against that. It's a very tricky line. I would say if it says, it's the military applicant rule. Well, I don't know what that is. Well, there's this law 43-1304 D1 that was passed the legislature that they wanted to talk to us about to see if we felt like applied. You stop there, I think you're okay. The second you say, well, I don't think that has anything to do, I don't think they meant that to apply to us, now you're a step too far. So,
Offer your opinion. I think that's when you've gone.
Answer. Thank you very much. That was very, very nice and very helpful. And it never hurts to hear those things. So, anybody else have any questions? If not, then thank you. The next item on the agenda is the legal report. So, Ms. Richardson, you want to address that?
Yes, we have one complaint before the council right now, and they have the summary, right? And the summary is before you, and I would just read it into the record. It is case number 2014-006701. The complaint alleges that one of the respondent's employees misappropriated funds and was convicted in criminal court. Additionally, this employee was never registered with the council as an employee. Respondent states that this individual was never an employee of the respondent entity. The individual was an employee of a community corrections agency with a similar name to the respondent, which caused the confusion. There are no prior complaints, and my recommendation is to dismiss the complaint.
A motion to adopt the recommendation.
So moved.
Is there a second?
Excuse me,
Okay.
one of the council members needs to recuse themselves in the discussion of this complaint.
That is, are you going to tell us or?
That would be me.
Okay,
Okay.
so we have a motion. Is there a second?
Second.
We'll do the vote by roll call vote this time, if you'll call the roll. And the motion is to adopt the recommendation to dismiss the complaint. So if you'll call the folks out.
Klein Lauterbach,
Yes.
Judge Hudson,
Yes.
Hugh Harvey,
Yes.
Dina McCullough,
Yes.
Stancil Ford,
Aye.
and Ms. Thornton recused herself. The motion passes, sir.
Motion passes, and you can show that the complaint has been dismissed. So what's your next item on there?
Item is the military applicant rule discussion. It's on tab 3. And then public chapter number 122, which I think Mr. Driver mentioned a different number for that, the actual statute number, was passed by the legislature in 2013, and it requires all regulatory boards to adopt rules to expedite the issuance of a license or registration to military applicants and applicants with spouses in the military. They meet certain requirements in the statute. A draft of the rules that legal has created, and the public chapter states that all the boards must adopt a process for a temporary permit for certain military personnel and spouses who qualify. Since this council only operates a registration program, there's a question as to whether these rules would apply to the council. We've created a draft that states they would apply for registration for companies that are sole proprietors that would meet these requirements. So we'd like you to please review the draft rules and consider whether you wish to adopt them.
Questions? Questions through reading it, or I have questions then. So does it apply to everyone?
The Public Chapter 122 requires boards to adopt this process for temporary permit for certain military personnel who would meet the requirements.
Yeah, who it applies to is either a and you see that statutory side in there. Who it actually applies to is either a military spouse.
Is that what the code section is?
That's correct. That it's the spouse of a military personnel who is transferred to Tennessee, who held the appropriate certification in the state that they moved from, and left their employment to come into this state, or a member of the armed services who was retired, honorably discharged, or released from active duty by a reserve component.
And this is to be the owner of a company?
That's it, because all of this commission, or all this council actually certifies or registers, are the actual companies themselves. And that's why when we were drafting this, it was drafted solely towards sole proprietors, because that's the only instance where it would even be applicable, because
But our rules do apply to probation employees.
only insofar as they, I can be corrected if I'm incorrect. Obviously, we deal with a lot of programs, and my familiarity with this program is less than some others. We require what companies are required to have their employees meet, but the actual companies are the entities that are registered.
Does this apply to aspiring probation company employees?
The way it is written now, it would only apply to the companies themselves. Because the
We don't
employees are
register,
registered.
we don't register
In
employees,
existence,
but the employees have to
operational in
fit
some other
the,
jurisdiction.
Correct.
but the employees have to fit meet the requirements to be an employee, the educational requirements, and most of the time, the complaints we get are about potential employees being turned down, so we do have to address those, even though we don't register employees. They do have to fit the rules of that the council oversees.
But this would not affect them, right? All of that would remain the same. If a spouse of a military personnel came to Tennessee and wanted to be employed by a private probation company, all the same rules would apply.
That's correct.
Is that correct?
So all we're talking about is someone who wants to start a probation company.
That's correct in those very limited circumstances. And again, if you're talking about any sort of corporate entity or limited liability entity, and speaking to Ms. Morgan or Ms. Whaley, whichever she prefers, that every single entity, honestly, registered in this state right now is either a corporation or a limited liability entity of some sort.
Does this open the door to non-military people who don't get the same treatment?
Again, this is from, and I can read you, I've asked that copies be brought down. I haven't received a response on that, but it says, notwithstanding any other law to the contrary, each board attached to the Division of Regulatory Boards shall establish a procedure to expedite the issuance of a license, certification, or permit to perform services regulated by such board to a person, and then it lists the qualifications. I think because it has that statutory site in there, that it only applies to the people that meet those
I
qualifications.
understand it only applies to that, but passing something specifically to those persons, does that open a door to people complaining who aren't within the military application?
Certainly, I think people could complain, but in this case, we have specific statutory directive from the legislature to open this very small door, given the field that you all regulate, to these people. So to the extent that they complain, the legislature's made their determination, and we're just trying to comply with what they have asked us to do as best we can.
Any other questions anyone has? Is there a motion that we adopt this? Actually, let me back up. Does this have to go to the legislature to be, how does this work?
Well, we have a couple of options, and it may make the most sense. The way it may make the most sense for this council to proceed, given your meeting schedules and the distances you all have to travel, there's a process called proposed rules, which is essentially you do all of the rulemaking requirements, the economic impact statement, Regulatory Flexibility Act, statement on local governments, adoption on the front end. The rules then go through their review process to the Attorney General's office and all that. They're published on the Secretary of State's website if either 25 people or a society of at least 25 people do not object to the rules within, I believe it's
Hold on, I have it written down.
90 days.
90 days.
90 days, then the rules are promulgated and then will go into effect 90 days after that without a rulemaking hearing. It's an alternative for what are rules that won't cause a whole lot of waves. So, bodies can promulgate.
You need special language in the motion?
What I would recommend is that you do the motion by roll call to adopt the rules, and then Ms. Richardson, I think, has the remainder of the statements that she'll explain to you regarding the economic impact and regulatory flexibility that you'll need to adopt separately.
Is there a motion that we adopt the proposed rule?
So move, Mr. Chairman.
Is there a second?
Second.
Ms. White, if you'll call the roll.
Klein Lauterbach,
Yes.
John Hudson,
Yes.
Hugh Harvey,
Yes.
Dina McCullough, Stansel Ford,
Aye.
Veronica Thornton.
Yes.
Record should reflect that the motion is passed.
Yes, sir.
Now, what do we need to add,
All right.
hear about in addition to that?
So before they can be adopted as proposed rules, the council needs to adopt a regulatory flexibility analysis and impact on local governments. I've prepared a draft of those, which you should have in this tab.
Should be the next page.
I will read them into the record, and if there are any changes you would like to make at that time, then we would have a motion to approve whichever statement, the statements as you would like to change them or adopt them.
We'll read that.
All right. The regulatory flexibility analysis is a couple questions that we have to answer. And so, number one, the extent to which the rule may overlap, duplicate, or conflict with other federal, state, and local governmental rules. And my proposed answer is that there will be no overlap, duplication, or conflict with other federal, state, or local governmental rules. Number two, clarity, conciseness, and lack of ambiguity in the rule. The rules are clear in purpose and intended execution. The implementation of the proposed rule change will not increase any ambiguity in the rules as a whole. Number three, the establishment of flexible compliance and reporting requirements for small businesses. These rules do not create any new compliance or reporting requirements. Number four, the establishment of friendly schedules or deadlines for compliance and reporting requirements for small businesses. The proposed military applicant rule will expedite the registration process for certain military personnel who hold sole proprietorships to provide private probation services. Number five, the consolidation or simplification of compliance or reporting requirements for small businesses. There are no new compliance and reporting requirements as a result of this amendment. Number six, the establishment of performance standards for small businesses as opposed to design or operational standards. And these rules do not set out operational or design standards. As such, there are no performance standards as a result of this amendment. Number seven, the unnecessary creation of entry barriers or other effects that stifle entrepreneurial activity, curb innovation, or increase costs. It does not appear that these amendments will erect barriers or have other effects which would stifle entrepreneurial activity, curb innovation, or increase costs. And those are my proposed answers to the regulatory flexibility analysis.
And read the whole thing. Read the whole thing.
Sorry?
Read all of it. We have to adopt each one separately?
So you can adopt all the questions as one.
I
That-
move to adopt the economic impact statement.
It's the regulatory flexibility analysis.
Regulatory effects, but I was just reading what it said right there.
You're saying you
want us to
adopt
adopt
each
each
statement
statement
separately, is that what you're saying?
So you can adopt all seven as a whole because it is the analysis.
All
as a
three
whole.
statements, economic,
Oh, all
regulatory.
three, yes,
You want them
sorry.
adopted, you want them adopted individually?
Yes.
Okay.
Sorry
All in
for the
favor of the motion
confusion.
to adopt the proposed regulatory flexibility analysis that was just read? Say aye, we'll do that by roll call
Do
vote.
we have a second on that?
Yeah, we need a second. We have a second
I have
for
a
that.
second. Oh,
Yeah,
I
I
second.
got this one, yeah. Motion to adopt the regulatory flexibility analysis.
I second that motion.
All in favor of that motion, indicate by responding to the roll call vote.
Klein Lauterbach.
Yes.
John Hudson, I'm so sorry. Hugh Harvey.
Yes.
Dina McCullough.
Yes.
Stansel Ford.
Aye.
Veronica Thornton.
Yes.
Thank
Record
you.
should reflect that motion has been passed. You want to read the next one?
All right, there are questions for the economic impact statement. Type or types of small business, and identification and estimate of the number of small businesses that would bear the cost of or directly benefit from the proposed rule. The proposed rule is a registration process that will apply to all individual or sole proprietor registration applicants equally if costs associated with this rule. Number 2, expected reporting, record keeping, and other administrative costs required for compliance with the proposed rule, including the type of professional skills necessary for preparation of the report or record. There are no projected reporting, record keeping, or administrative costs for small businesses. Small businesses and consumers. This rule has no projected impact on less burdensome, less intrusive, or less costly alternative methods of achieving the purpose and objectives of the proposed rule. To what extent the alternative means might be less burdensome to small business. No less burdensome, intrusive, or costly methods to achieve the purpose of the rule. Number 5, a comparison of the proposed rule with any federal or state counterparts. There are no federal counterparts to this rule. Public Chapter 122 requires all regulatory boards to adopt rules expediting licenses for military applicants and applicants with spouses in the military. The boards are adopting rules substantially similar to this proposed rule. Number 6, analysis of the effect of the possible exemption of small businesses from all or any part of the requirements contained in the proposed rule. This rule does not require small businesses to change their operations. Therefore, there is no need for an exemption.
A motion to adopt the economic impact statement.
I so moved.
And a second.
Second.
Do a roll call vote.
Klein Lauterbach.
Yes.
John Hudson.
Yes.
Hugh Harvey.
Yes.
Dina McCullough.
Yes.
Stansel Ford.
Aye.
Veronica Thornton.
Yes.
Record should indicate that motion is passed.
Yes, sir, it passed.
Now read the next statement.
All right, the next statement would be a local government impact statement. And this rule has no projected impact on local governments.
Motion that we adopt that statement.
So moved, Mr. Chairman.
Second.
If you'll call the roll for that vote.
Klein Lauterbach.
Yes.
John Hudson.
Yes.
Hugh Harvey.
Yes.
Dina McCullough. Stansel Ford.
Aye.
Veronica Thornton.
Yes.
Passes, sir.
Okay. Then I have the motion to adopt the rule,
That's correct.
so we can skip that. But
We need another motion to do anything, or does that take care of what you
if
need?
we already did it earlier, so we can
Okay.
skip that one. But I would ask for the board to consider a motion to allow me to proceed with these rules pursuant to a rulemaking hearing. Required request for a hearing be received. So if enough people oppose the rules, we would have to go back and do the rulemaking hearing. So I'm requesting a motion saying I can go ahead and schedule the hearing and prepare it without coming back.
Someone make a motion to.
I make a motion, as council stated, that she proceed without the rulemaking hearing.
Schedule a hearing, is that right?
To proceed with proposed rules at this time and to go forward with a rulemaking hearing should sufficient request for a hearing be received.
I have to say that?
You can do what you did, which is, so long as you understand and agree with it, you don't need to restate it.
We'll capture it all in the
Is there a-
minutes.
Is there a
Thank-
second to that motion?
I second.
Is there any questions about that, what that means? If you'll call the roll.
Klein Lauterbach.
Aye?
John Hudson. Hugh Harvey.
Yes.
Dina McCullough.
Yes.
Stansel Ford.
Aye.
Veronica Thornton.
Yes.
The record should indicate that.
Passes, sir.
And that is all I have,
Does that tidy you up there and get what you need?
I have
Okay.
everything I need, thank you.
Yes, sir. Is there anything else on the legal report?
Nope.
Okay. We'll move on to our director's report, the administrative report. Ms. Whaley.
Yes, on tab 4, you will find your revenues and expenses through April. And this is just for informational purposes. We present this to each of our boards.
The first page is just the, shows how much fees,
Yes, sir.
We received in
This
April.
is the revenues.
and then the next one is just the,
The next one is a detail of the expenses through April. As you can see, there's $100,296.61 in revenue, and year-to-date expenditures are $17,072.83. Your expenditures are before the year-end closing administrative expenses and the regulatory fee, which for this board is very small, given the number of registrants that the council has. Sorry?
column on the left.
Oh, no, sir. The column on the left is the budgeted amount. This allows the staff to keep up with how they're doing compared to budget. The far right-hand side is.
That's just the, when it says work plan, that's your budget amount.
Yes, sir.
Okay.
That's our term for budget. Does anyone have any other questions?
If you want to go into the next one on your
Yes, and
agenda.
actually, tab 5 is an application for a new agency. And I would actually like to ask the council's opinion. It was my understanding that all new applications were presented to the council for approval. And I want to see if that holds true or if there's another process the council wants to proceed
We had
under.
discussed at one time that unless there was an issue, it didn't need to be brought before us.
Okay.
Is that,
That is it? Okay,
Correct.
wonderful. This is very recent, and just being new to the process, I wanted to confirm that we undertake things. Some boards and commissions, their opinion changes and it varies, so I just wanted to ask the opinion. There was nothing about this one that was different or unique. This is actually, I think, the first one we've had in a number of years. So again, bringing it back just to make sure. With that being said, there's nothing for you to review unless you do want to review it. They provided all of the policies, procedures, the information regarding their employees. Yes, sir. This was just a confirmation for me, serving in your director role, to make sure that I am meeting the council's expectations and presenting you what you need to see and not anything that I have and also too, what you have here is just a very small snippet of their application. I actually have the entire application here.
Well, I'm
Certainly. Certainly. This one just coincided with the meeting, so. If there's nothing on that, we do have one final item. We've received an email from a gentleman who is, it's my understanding, an owner of a private probation service council or service company, and Ellery has prepared a brief summary of his question. I have also attached the emails of his actual question. And we're seeking the council's input. We just received this a few days ago.
Yeah, I can.
Okay.
The summary from, I read the email, and from what I could tell, his question was regarding Administrative Rule 1177-01-.08, which discusses the quarterly provider fee. That rule states that for purposes of this rule, caseload means every person assigned to a court or assigned by a court to the private probation service provider for probation services who reports for supervision in person, telephonic or written communication, or is supervised at any time during that quarter. And the company was seeking clarification. He's been collecting a supervision fee from people who appear in person or have an associate appear on their behalf. But he has not been collecting a supervision fee from people who are incarcerated. However, he still feels that the company is supervising these people. And there are also a couple of probationers whom warrants are issued against them. And he is not technically supervising them, but he feels that he is, because instead of seeing them in person, he monitors newspaper articles and jail rosters looking for them. And so he just wanted a clarification with that quarterly provider fee.
I think it was our decision previously that responders, they were in jail, if they're on their supervision roles. Got some feedback and some
Judge Hudson, your
Concerns.
mic isn't on.
all right, that's all right. It was my understanding that we decided that the probation companies would pay for all of it. Drift back into the probation and they drift out and they end up in jail in another county. Follow through, you know, sitting as judge, I want to know, where is this guy? Well, Judge, we've checked and he's in the Overton County Jail. How long is he going to be there? We don't know. Is there a new charge? Is there a violation? All those things require follow-up by probation officer.
I would think until they're formally discharged, revoked, expiration of sentence, that I think it would be an accountability nightmare to start trying to make caveats for.
I wonder if he still charges them his monthly fee.
He says he has not been collecting a supervision fee.
For an issue from charging it and putting it on their little statement. Not collecting it because they're all disappeared on him. That's not an uncommon thing, by the way. I'm not sure about state probation, but for General Sessions Court, they hit the road all the time. And they show back, and here's what happens. They show back up with a new charge 2 years from now. And I imagine none of those probation officers go back and waive any fees from the old days. And, you know, who knows where the line was when they said, okay, we can't find this guy, and then they stopped charging. I think Judge Hudson's right. That's a nightmare that's just hard to.
So,
Curious who they have associates that appear on their behalf. That's curious to me.
That's the wife that's on probation that comes in and pays the fee for that.
Right. And she's doing that so that she comes in and pays the fee. They're letting the defendant get away with that because they don't give them a drug test. That's why they'll send somebody in. They'll take in the proof of the community service work and say he had to go to work today, and they're avoiding the possibility of a drug test. And companies shouldn't allow that. I mean, they ought to take their money and the records that are brought in. They shouldn't count that as an appearance by that defendant. Instead, should still show that he's not showing up. But that's up to that company. But I think, anyway.
so let me just repeat it back to you to make sure I understand. you're saying that they should be paying a quarterly provider fee for even these probationers that they don't know where they are. That's correct. Okay. I might suggest that maybe you can discuss this, maybe a rule kind of addressing that to include, since this definition of caseload isn't entirely clear about that, whether you think a rule will be necessary for that clarification, or if
I don't think we need to add anything. It says or is supervised, and
Okay.
if they can't find them, that's their problem. There's a way to go about that. The probation company can file something with the court to be excused. A judge might or might not do that. For example, it's easy to do. They come to court and say, he's in federal, I'm in Bristol, Tennessee, and Virginia's, I can throw a rock to the state line from the courthouse. And he would say, they're in custody in federal court in Southwest Virginia someplace, and he's serving a year and a half. He's going to come back. We'd like to be relieved from probation. You might not do anything with arrest warrants, but you might choose to eliminate that person from supervision.
Okay.
I mean, it's a judge's decision. If if the probation company's prepared all the work it needs to cause the court to issue an arrest warrant, then there'd be a reason to release them. There's no reason to have them there.
Okay, no, that makes sense. Just, I wasn't familiar with your industry as well as you are, so I wanted to see, but.
Frankly speaking, you know, if this person's on probation already somewhere else, if this person is on probation somewhere else already, I'm not going to do that. Just an economic.
I think the answer to his question is, yes, he's supposed to pay that.
All right,
Yeah.
thank you.
We will respond back to Mr. Cannon with the commission's response. I have in our notes that it's been probably over a year since you've elected officers. And I have that on the agenda. That is something I will present to the council if you want to take that up, or
Do we do
think it was
that, do we do it at the September meeting?
you certainly may.
I mean, I'm not sure when, I don't remember when we did it last.
I don't know if you did it, I don't show where you did it, but September is perfectly all right. It was more to bring it up as a conversation.
We always did it annually, I think.
Yes.
And I was thinking I may be wrong, I can't remember what meeting it was.
This
when
is
it was.
you met in March. Prior to that, you met last June. So, we can certainly take it up at the next meeting. I can put it back on the agenda.
Happy with the current administration that we have.
Why don't we do it in September?
Kept all their promises.
And-
Absolutely.
And can you look at the records and see when we did it last? But I think we always had it on we did it on an annual basis. And it may have been the June meeting, I just don't remember.
Well, seeing that you didn't meet in September
Right.
makes,
It
I believe it's been over a year, but that you can serve until.
Wait till the September meeting, and hopefully all 7 people will be present, and we can do it.
Certainly, I completely understand. That is all of the business that I have.
Is there any new business to be brought up that anyone has, or
Covered that with
council or
the,
director, anybody else has anything we need
email.
to bring up, other than what you just talked about? Anything else we need to discuss? Is there a motion that we adjourn the meeting?
So move, Mr. Chairman.
Okay, all those in favor say aye.
Aye.
And their next meeting is scheduled for, we ought to just go ahead and say that on the record. Their next meeting is
yes,
September.
September,
Was that Friday?
I think it's like the 6th, 7th.
I think it's,
That fall in conjunction with Labor Day, is that something we need to?
The next meeting is scheduled for Friday, September 5th.
Labor Day will be,
Labor Day the first Monday, the first is a Monday, so it would be the Friday after Labor Day.
so September 5th. All right, we're adjourned, and we'll see you then. And thank you for all the new people. You're welcome.